many of the US consulates and embassies around the world had to close, and it's been extremely difficult to get visas, which you probably all know can only be obtained at a US embassy or consulate around the world. It is not possible to get a visa from inside the United States. While these consulates originally closed due to COVID, it's our opinion that they remain closed because that's very convenient for the Trump administration to limit legal immigration. Let's face it, President Trump has insisted that America get back to work, that it's safe for businesses to open. Yet he's somehow convinced America that we have to close the consulates, and they can't be open because it's too dangerous under COVID. The truth is they could open, they could get back to business, but they're not because the Trump administration is not letting them. The good news is we expect under a Biden administration that the consulates are going to open if it's safe to do so, and they will ramp up and be back to processing visas as before. We need to note, though, that normal will not be the same as it was before. There will be more significant delays. It'll take a long time to get back on track after these consulates have stopped issuing visas for so long, and there'll be such a backlog to get through. It is, for those consulates that are open, it's still very tough to get an appointment because so many people are trying to get these appointments. One positive thing happening right now is that most consulates that are open are happy to entertain people from any country around the world. For example, the US consulate in Paris is open for non-immigrant visa processing, and they're accepting people from any country if you can get to Paris. That's good. That's a lot of good news right there. Of course, if you get to Paris, you're going to be subject to a COVID-19 travel ban that currently is in place for people who are inside any of the Schengen countries in Europe, plus the UK and Ireland and China and Iran. And if you're inside those countries, you will not be allowed to enter the United States until you're outside those countries for 14 days. So what do when you have key employees or staff or executives that need to travel and they need to come to the United States? Well, one solution has been to depart the country where there is a COVID-19 travel ban and stay inside a country with no travel ban for 14 days. Examples are in Europe. Turkey is not part of the Schengen. There's no travel ban on people coming from Turkey or Croatia, and the same is true for Mexico and Canada. So many people are trying to go to those locations for 2 full weeks and then entering the US. But there's also a waiver process. It is possible to ask the US government, either a consulate or a Customs and Border Patrol office at an international airport in the United States, for a waiver. And we've been very successful in obtaining waivers based on the national interest of our country. And we are taking any possible work that's being done by your company that could be in the national interest and articulating why it is really essential that this particular person be able to come to the US for a very short period of time to get certain work done. As the Biden administration takes office in January, we expect them to reevaluate all of these travel bans, and they're going to let science dictate whether there is really a need for a travel ban rather than politics, because clearly most of these travel bans remain in place because of the Trump administration's efforts to curtail legal immigration. Mike, do you want to talk about temporary work visas?
Yes, my name is Mike Haven. Hopefully you can see me okay. The lighting situation is not great here. But so under the Trump administration, we've seen repeated attacks on the H-1B program. It's come in many forms, and it's been sort of constant over the last 2 to 3 years. And it's clear that had they won a second term, then they would have continued these attacks. And the most recent that we've seen were the somewhat surprising interim rule increasing the fair prevailing wage and redefining what will be considered for a specialty occupation. Now, this rule was announced with no notice, with no period for public comment, as is the norm, and which really is what the Administrative Procedures Act calls for. And it was just sort of a shock to the system, and it really caused a lot of worry among employers and their employees in the United States. The interim rule regarding prevailing wages for high-skilled H-1B, H-1B1, or E-3 non-immigrant visas from Australia drastically increased the wages that employers have to pay their employees. In some cases, for computer-related positions, as much as 50% for level 1 wages. So it was really just sort of out of the norm, and really not based on any sort of economic analysis whatsoever. This immediately came under attack from various organizations, and currently there are a number of lawsuits that are pending. And based on what we've heard from lawyers involved in the lawsuits, it seems pretty clear that there's a very good chance that there will either be an injunction on this rule while the case weaves its way through court, or it is possible, based on some indications that one of the judges has given, who's handling the case, that it could just be just thrown out of court and overturned outright. Obviously that would be the best case scenario, but even if that doesn't happen and the rule is allowed to stand, we expect that under the Biden administration, they would have the Department of Labor reevaluate that and most likely rescind, because it just doesn't make any sense economically or based on the law. It's really not based in any law. And the Small Business Administration, one of the Trump administration's own organizations, has come out and said that we've got to put a pause on this. This rule really is disruptive, and it doesn't make much sense at all based on the economics. One of the things they pointed out was that a justification for the rule was that there was high unemployment. But when they looked at the numbers in most of the technical fields we're talking about, there really was not a huge increase during the COVID pandemic of unemployment. So that argument really doesn't really hold any water. The other part of the rule that came was creating a more stringent definition of what's considered a specialty occupation under the H-1B rules. So the government is trying to make there be a more direct relationship between the employee's degree and the specific job duties of their position. Now, our office has sort of been doing this the past 2 years anyway. We've made it a point to look at the coursework that an employee has done over the course of their degree and relate it specifically to a job duty. So we were already doing this, but it looks like the administration really wants to harp on this and make it harder for employers to prove that the degree is related to the job in which they'll be carrying out. And then they'll also want employers to show that this position always, not sometimes, not usually, not normally, but always requires at least a bachelor's degree. That's not how the rules are written. That's not the law. So it just flies in the face of everything that the Immigration Nationality Act actually states. So needless to say, we feel pretty strongly that it's just not going to stand up in court. And if it does, by some miracle, then we feel that the Biden administration is not going to allow this to proceed. It just doesn't make any economic sense. They had also discussed ending the random lottery-based system for the H-1B. And this one is also very shocking. They want to have it so that it's more dependent on salary rather than somebody's specialty occupation and their degree. So that instead of doing a selection randomly, they'll select cases based on whether or not the person is being paid maybe a level 3 or a level 4, the higher wage levels that you can find in the Department of Labor's wage levels. So that as well just flies in the face of what the law is intended for and puts an emphasis on somebody's salary as somehow indicative of their value to American society. So again, it's being challenged in court, and just as the other lawsuits seem to be heading in a direction of injunction, I think this is headed in the same direction. We're very hopeful that this is not going to be allowed to stand. It is scheduled to go into effect on December 7th. I'm sorry, for next year's lottery. I got ahead of myself. For next year's lottery, but we're hopeful that it just will never come to that. Under a Biden administration, the lottery will go back to the way it was last year. It was very successful, I have to say. We were skeptical, but they actually implemented a really good system of registration, and only those that are selected in that registration process then file a full application with the government. And it worked very well. So employers may register foreign nationals to enter the H-1B lottery in March of 2021, and the lottery will be conducted on April 1st. And then the winners have until June 30th to file H-1B petitions. And there is also a second round for spots that are unused by the people selected in the first round. If they don't use that cap space, then there is a second round, and we've had some clients who are selected in the second round.
Excuse me, can everyone please put themselves on mute? Can everyone please put themselves on mute? Thank you.
Okay. And then finally, the Trump administration, really since day one, has been putting rumors out there that they were going to get rid of work authorization eligibility for spouses of H-4 employees.
I'm gonna jump in for a second, Mike. I'm sorry. There's someone on the line who needs to put themselves on mute.
Okay. So as I was saying, they've been talking about getting rid of work authorization eligibility for spouses of H-1B holders who have approved I-140s for a very long time. And, it looks, anything is possible in the next 2 months. I think that we're going to see them try to just throw everything and then just try to go out in hell of bullets and see what happens. But I don't think they're going to have enough time to actually get this through or even propose it. This does bring up another point, which I'll discuss later, about work authorization documents for spouses and how long they've been taking. So we'll discuss that a little bit. But basically, I think if this rule regarding the prevailing wage is allowed to go forward, or if it's around for a little bit longer, you're going to want to file your extensions for H-1B or for E-3s or whatever status you might be under as early as possible, and seek alternative wage surveys. You do not have to get the wage level determination from the Department of Labor. There are a number of alternate wage surveys that will give you a wage level that is based more in reality, frankly, based on more economic data, and those have been working. We use those surveys as opposed to the Department of Labor's, and we file the H-1Bs based on that wage level, and those can get approved. They're in very high demand right now, so it's very important that people try to get these as early as possible, start the extensions early, and ask for these alternate wage surveys early, because there aren't many companies doing it, and there's a lot of demand. Okay, Danielle, you can go to the next slide.
Did you talk about the H-4?
Yes.
Yes.
Sorry.
Okay.
Great.
So green cards. So the prevailing wage rule that I just discussed also has an effect on green cards based on the perm process, with some of you may on this call have gone through already or are in the process of. The wages that as of now, the Department of Labor will be looking at are drastically higher. And one of the problems with potentially using the alternate wage surveys for a perm process that I had mentioned is that they normally are not valid for more than maybe 3 or 4 months. And the perm process has now taken, well, it's up to about 5 or 6 months from the time you submit the form. And there's somebody in our office who worked for another office before, and they had a scenario where they used an alternate wage survey for perm. And by the time the perm was ready to be certified and given a determination, the survey had already expired and the case was denied. So it's a little bit of a risk, I think, to use alternate wage surveys for perm. But again, hopefully this rule will be overturned and you won't have to worry about it. I think, again, under the Biden administration, even if the rule sticks around, they'll hopefully get rid of this drastic wage increase and we'll go back to the old, or at least something that is a little bit more based on actual economic data. Right now, we're seeing a crisis level delay in green card processing. I mean, it's just across the board, all different categories. From the time you file to the time you get an interview, it's just taking an obscene amount of time, longer than we've ever seen it. Some of that, I think, is rightly due to COVID, but a lot of it, I think, is intentional. It was happening before the pandemic, and the pandemic has certainly made it worse. But it's very hard to gauge these days how long a green card application is going to take. On the one hand, we've seen in most employment-based categories, they have been foregoing the final interview in person. So that's one good silver lining, I suppose. A lot of our clients in EB1A for extraordinary ability or EB2, employment-based preference 2, have been getting their green cards without an interview. They just get an approval in the mail. And that's the way it used to be before the Trump administration started interviewing everybody. And that's one of the reasons that there were delays initially. So wherever you are in the process for a green card, you can expect that you're going to have to wait. And we expect these delays to continue into the Biden administration initially, of course. It's going to take them a little bit of time to get in there, put some new appointees in there, and change the culture really back to a more efficient organization. So you can definitely expect increased efficiency and expanded premium processing as well. That's something that under this administration they were going to try and institute, and that is premium processing for more categories, such as multinational green card managers. It's called EB1C. They're going to try to allow for premium for many other categories. So hopefully that will also speed up the process a little bit. We don't know exactly where they are in that right now. It's been delayed, but certainly under Biden, we'll hopefully see a increased efficiency. And yeah, I think it'll just slowly turn into a better experience overall for employers and employees.
Coming up in the future, there's certain legislation that we think everyone should be looking out for. At joebiden.com, there are proposals for a new visa category to allow cities and counties to petition for higher levels of immigrants to support their growth. It's a very exciting idea, and there has been some limited experience with this before in the Detroit area, but the proposal is to expand it across the country and to permit different geographical areas to prove to the Immigration Service that they really need immigrants to come in and help them grow. And we are expecting to see that not on day one of a Biden administration, but at some point in the near future. We also expect a return of legislation to create an entrepreneur visa category or some kind of entrepreneurial parole. Under the Obama administration, there was an entrepreneurial parole legislation that was put into place and was just about to take take effect when President Trump took office, and he canceled it within his first couple of weeks of being in office. We expect an entrepreneur visa or parole to benefit those who have received some kind of significant funding from a recognized U.S. venture capital entity, possibly a minimum of $200,000, maybe $250,000. And there also has to be some component where these, the entrepreneur will be part of a startup that will be creating some kind of significant jobs. It's much needed, it's great for the economy, and we're looking forward to seeing what the Biden administration does for that. And also, the Biden administration has promised that once they are sure that they have an immigration system which does not undercut the wages of US workers, they are all about increasing the numbers of high-skilled visas and green cards. Among the Biden administration's proposals are that all PhD diplomas in STEM fields will come with a green card basically stapled to the diploma. They will be a higher level of issuance of H-1B and L-1 visas that will be closely tied to the needs of the labor market. An increase in high-skilled H-1B visas. So this will take legislation to change the historical cap of 240,000 employment-based green cards a year, but we think that is coming, and I think it's going to be a bipartisan effort once the Biden administration really proves to America that immigrants are not depressing the wages of US workers. And there could be some tie to a possibility of decreasing the amount of employment-based green cards when the Department of Labor can prove and show that unemployment is high enough in certain sectors that we do not need more employment-based green cards at that time. I think all of these are positive changes that will help the economy, things that are good for America, and long overdue. There are certain immigration strategies that we propose to our clients every single day, but specifically in the future, we see an expanded use of the National Interest Waiver green card category. The National Interest Waiver permits a foreign national to sponsor himself or herself without an employer being involved. What's required is that the foreign national prove that he or she is involved in a field that has substantial intrinsic merit to the United States. It must be proven that the foreign national is well situated to continue the beneficial work. Basically, if they're employed legally in the United States, they're going to be able to prove that they're well situated to continue the work. And the hardest part of a national interest waiver is proving that the impact that to the United States that the foreign national brings, or this particular foreign national brings to the table, is above the norm and outweighs the benefit of the perm labor certification process, which basically is the test of the labor market to see if there's any US worker who is able to do the job. Basically, it's proving that this foreign national is more important than the general idea of saving US jobs for US workers. The reason I think there's going to be an increase is because the backlogs are so long and they're getting longer that if there is not a bipartisan agreement to increase the numbers, the backlogs are going to be so long that people are going to look for ways to speed up their green card process, and EB-2, National Interest Waiver, is one way to do that. For those who are from India and China, they want to file a National Interest Waiver green card to establish their priority date so they can get into the queue, so that if there is a long backlog, at least they are in the line with a certain date. And that's important moving ahead. Lastly, I want to talk about CAP-exempt H-1B visas. It's important for people on the call to understand that not all H-1Bs are subject to the annual cap of 85,000. Congress has declared that there are 4 kinds of organizations that can always sponsor an H-1B any time of the year without winning the H-1B lottery. And these 4 organizations are universities, nonprofits that are affiliated with a university, nonprofit research organizations, and government research organizations. What's really interesting is that the regulations state that once a foreign national has one of these CAP-exempt H-1B visas that were sponsored by one of the 4 CAP-exempt organizations, any company, any US company can piggyback on top of that CAP-exempt status for the foreign national and file their own CAP-exempt H-1B immediately without winning the lottery. So if you have a foreign national and they've lost the lottery and they've got nowhere to go, you might want to consider whether they could possibly get a CAP-exempt H-1B so that your company can benefit as well from the CAP-exempt H-1B status. So there's 2 different kinds of CAP-exempt H-1Bs. One is if the foreign national is located at a CAP-exempt organization, and the second more common one that most people are using is if the foreign national is employed by a CAP-exempt organization. And this is where Open Avenues, the co-sponsor of today's event, comes into play, because Open Avenues is a nonprofit organization that's affiliated with universities. And then not only are they doing tremendous things to benefit foreign nationals in general, but they have established their own CAP-exempt H-1B visa program. And Danielle, I'm hoping you can tell the audience more about the Open Avenues program.
Yeah, thanks, Jeff. And I'm just going to ask everyone to put themselves on mute again. Someone's not on mute right now. Thank you. Awesome. So yeah, so as Jeff said, Open Avenues is a CAP-exempt organization. We're a nonprofit affiliated with universities in the Boston area. So we're partnered with different universities around Boston, and we run a program called the Global Talent Fellowship, which we open to foreign nationals working at STEM companies or foreign nationals who have started their own company. And we offer the Global Talent Fellowship to folks to work with us for 5 hours per week. That's the commitment. We're looking for individuals who have experiences in STEM and business. We obviously are looking for folks with a strong specialty occupation, because the same qualifications of H-1B apply for CAP-exempt H-1B petitions. And once an individual is accepted into our fellowship program, we do file a CAP-exempt H-1B visa for them. And their full-time employer is able to then, as Jeff said, piggyback or concurrently employ folks in a CAP-exempt H-1B status. And so we have 10 Global Talent Fellows that are in our fall 2020 cohort. They'll be working 5 hours per week with Open Avenues and full-time with their employers. We have mechanical engineers, software developers, data scientists, chemists. It's a wide variety, and we would love to talk to you if you're interested in the program. Or if your employees are interested in the program and you're someone who works in HR, this is an amazing leadership development opportunity for foreign talent as they're leading students through project-based work and really training the future workforce. It's an awesome initiative. So please reach out to me if you're interested in learning more about it for yourself, for your company, or for someone else you know. And Jeff, if you want to move on to the next slide, that'd be great. You're on mute, by the way, Jeff. Hey, Jeff, you're on mute.
Coming down the road, there are a few more recommendations that we'd like to suggest. Companies need to manage expectations, and they need to manage the expectations of their employees, because everything is going to take longer until COVID-19 is fully under control. And even then, it will take time to get back to some normal time frame that we can all rely on. Right now, it's really hard to rely on any particular time frame. We suggest that waiting for the Biden administration may not always work. We have several clients calling saying, we want to file for an H-1B or an O-1, an L-1, but we'll wait until Joe Biden is president. The reason it may not be prudent is because certain measures can change overnight, but many things cannot. And it will take time to change the culture at USCIS and the State Department. At our firm, we believe that if you have a strong application, go ahead and file it. We're getting mostly approvals, as are most other good immigration law firms. And there's no particular need to wait. It will get easier in the future, but if you have a strong case, there's no need to wait. We anticipate that the higher H-1B and perm wages will be thrown out by the courts even before President-elect Biden comes to office. And many of these court challenges have already been heard. The judges have already taken it under advisement. And frankly, the decisions could come any day or even in the next few weeks to throw out the increased wage requirements.
Awesome. So here is our contact information. If you have any immigration questions or you want to follow up on today's presentation, please email Jeff and Mike. And then any questions regarding CAP-exempt H-1B visas or the Global Talent Fellowship, you can send them to my email address, Danielle@openavenuesfoundation.org. And please check out our website. We just relaunched it today, so it's brand new, and you will be able to find more information out about our programming. We're going to start opening it up to questions, and I will say that if you are unable to answer a question today or something comes to you later on, please email it to either myself or Jeff. We will be collecting questions after the presentation and sending them back out to everyone because we believe that these questions will be ones that most people will want answered. So I'm going to stop sharing my screen, and I think we might have a few questions in the chat, but please, if you have a question, you can just hop on video and ask it to Jeff, Mike, or myself. Or you can ask on the phone.
Danielle, I can start off by answering one question I saw on the chat. The question was, I don't know if I have it right because let me see if it's still here. Yeah, it said, hello, Jeff and Mike. Which of these proposed immigration bills do you expect to have bipartisan support on Capitol Hill? I mean, that's a really good question. There hasn't been much bipartisan support for anything immigration related going back even before the Trump administration. So, you know, my personal opinion is it's never easy to predict what would gain support on both sides of the aisle. That's certainly tricky. One thing I will say is that immigration law is one area that the Constitution grants the president really broad powers, and they can do this through executive orders, which we've seen President Trump do a lot of. President Obama did the same thing. So presidents can really affect immigration law without bipartisan cooperation. Obviously, for long term, it's always beneficial that both sides agree and legislation is passed and it becomes a written law. We have seen how difficult that's been for them to do in previous years. Of course, we hope that, obviously, if, you know, a lot depends on the last two Senate seats that are still out there in Georgia. But assuming those went Republican, then it would become a little bit harder for sure. But we'll see where things go. Notwithstanding that, though, you know, President Biden is going to have a lot of power to rescind some of the things that Trump did, but he's going to have to do it in a proper way. He can't just do it on day one without following proper procedures. Many of the things that the Trump administration wanted to do were eventually overturned because they just simply didn't follow the rules. They didn't do things in the proper way. So I would assume that, you know, President Biden will not act in that manner and will do things a little slower perhaps, but at least in the end goal, it'll stand under scrutiny and not be overturned by the Supreme Court.
I see another question in the chat that I'll ask quickly. It says, hi Jeff, are there any chances that S386 getting passed under the Biden administration, which for those who don't know is the Immigrant and Nationality Act, which would eliminate the per country numerical limitations on employment-based immigrants? So Jeff, if you want to take that one, or Mike, that'd be great.
Yeah, the Biden administration has indicated it is in favor of getting rid of the numerical cap, the numerical country cap that's currently in place under the Immigration and Nationality Act. The rule currently states that no country can use up more than 7% of any of the available visas. And right now, China and India regularly always exceed more than 7% of the available visas. And that is why they have an extra long backlog for immigrant visas for people to get green cards. So the president has said he's in favor of getting rid of the per country caps. Those caps were created decades and decades ago, before there was a global economy, before America was as diverse as it is today. And the reasons those laws were created just don't exist today. To be honest with you, I was also in favor of getting rid of the cap until I wasn't, because one of the versions that has been pending in Congress to get rid of the caps propose that if they get rid of the caps, every single person who's already in line will come first. Well, if that's the way it's going to happen, that means that for the next 10 years, 100% of the employment-based green cards will go to people from India and China. And nobody from Canada, the UK, or any other country will be getting an employment-based green card for the next 10 years. That just doesn't make sense to me. I think there has to be a better way to get rid of the cap with a very, very slow, methodical change in circumstances. Or let's just get rid of the overall cap and give everybody a green card at the same time if they're eligible and qualified. But we'll see what happens. But the Biden administration is in favor of getting rid of the per country cap.
Thank you.
Go ahead, I see another question.
Yep, so the question was, in order to apply for a perm labor certification for a green card, does it have to apply on a new wage? Does that make sense to you, or do we?
Right. The first step in the perm labor certification process is to obtain a prevailing wage determination from the U.S. Department of Labor. So you put together a strategic job description that is fair to U.S. workers, and you submit it to the U.S. Department of Labor. They are currently using the higher wage survey that the Department of Labor just issued last month. And you don't really have a choice. That's the wage survey they're using. You can try to submit your own wage survey, but they don't have to accept that. And determinations have been issued in the last 3 weeks using the higher wage survey. It has happened to a couple of our clients, and they've opted to not move ahead right now. I think they're filing new wage determination requests all over again, knowing that these take 4 to 5 months for the Department of Labor to issue the request, and hoping that their new wage determination will be issued under the Biden administration without the higher wages.
Thanks. Mike, there's a question for you in the chat. It says, does your advice, sorry. It says, you mentioned that except if we have a strong case to file a visa request, we should better wait for President Biden to take office. Does this advice apply to any type of visa or to some visas in particular? Also, are there some specifics you can share regarding the renewal of TN visas during the change in the president's transitional period?
Yeah, actually, it's actually the opposite that we recommend. I mean, if you have a very strong case, you should go ahead and apply now. We are getting cases approved all the time, and not just for strong cases, for all sorts of cases. So I don't think it's beneficial really to wait at this point. Biden has a lot on his plate, and immigration is not going to change overnight. So a lot of the same policies will have to remain in place for a little while. And we have every confidence in the world right now in our ability to get cases approved. We're getting them approved at an extremely high level with some pushback. I mean, it takes a little bit more work now, but the end result is approval. So that's really all you need. So I would say, don't wait. You might have specifics to your case if we looked at them where we would say, all right, maybe it is a little better for you to hold off. But in most cases, I would say you're probably not going to need to wait.
With respect to filing TNs during the change in the administration, go ahead. There's no difference. TNs have been adjudicated the same in the last 4 years as they were in the 10 years before that. Good TN applications are being approved and bad ones are being denied. And there's nothing different going on now or during the transition.
Habib, do you want to jump back on and ask your question?
No, that's very clear. I just wanted to clarify that my question had to do with visa requests that didn't necessarily present themselves as a strong case, rather than the opposite.
Okay. Yeah, I mean, as I said, I think that would depend on a case-by-case basis, but yeah, in most cases, I would say you're probably going to go forward now.
Thank you.
Great. And let's move on to the next question. Are H-1B transfer petitions with premium processing straightforward under the current transition period? And a big thank you for all your work.
H-1B transfer applications, I think the question is referring to a foreign national who's moving from one company to the next. They've already been counted against an annual cap, and so their new employer can immediately file a new H-1B petition. The word transfer is actually a misnomer. You don't transfer it by picking up your H-1B and bringing it to the next company. The second company must apply all over again and prove each and every requirement of H-1B all over again. But I think the question is, are they going smoothly? Yes, except for the new wage requirements. And that's why Mike is clearly telling you need to consider an alternative wage source, because you don't get to keep your old wage when a new company is filing a new H-1B petition.
Right. And the only other thing I would add to that is they're going well, as Jeff said. What's changed from a few years ago is we would have many clients who might start working for the new employer on the day that the application was filed. But those days are pretty much gone because people want to wait to see that the case has been approved in most cases. So that can sort of extend the time out where you give your current employer notice that you're going to be leaving. So it just makes the transition a little bit longer. But certainly the approval rate is still good. And with the new wage increase, we have to be a little bit more careful. But other than that, yeah, I would say transfers are going very well.
Okay. And then there's a question about L visas, which we didn't really talk about through the presentation specifically under the temporary work visas, but are same rules applying to L visas? And if anyone's thinking about an L visa, what would your advice be right now?
Well, L visas are still viable. There's still a big need for L visas. Real briefly, an L visa is for a multinational company who's going to transfer an employee from outside the US who's worked outside the US for at least 1 year and transferring them to work for the US entity of part of the multinational company. We have not stopped filing and getting approvals of L1 visas. We're doing them by premium processing. I think we get more RFEs on L's than on anything else, but we're not afraid of RFEs, and neither are most attorneys, because it's part of what we all do. And you should expect an approval of an L visa. There is the travel ban on L visas, but it's the same as the H visa travel ban. But important to know, That travel ban on H&L visas only affects people who were outside the United States on June 24th. That was the date that the Trump administration issued the proclamation banning new H&L visas. And it only affects people who are outside the US on June 24th and who did not already have a visa. So luckily for us, most of our clients were inside the US on that day, and they're still able to get L visas and enter the US. But there's no reason to really shy away from trying an L1 right now.
There's a question about whether or not you anticipate there being any changes to 3-year work permit post-degree. I think Marianne is referring to OPT with a STEM extension, if you're reading it the same way, Jeff and Mike.
Well, yes, the Biden administration has proposed drastic changes to OPT. And I think they're never going to come to fruition. The American university system widely relies on foreign students to come to the US, add to the US, to the university culture, and to pay full tuition. And they are not going to have it if these foreign nationals are going to lose part of their OPT. The STEM OPT category has worked very well to prepare people for the US labor market, and I think, I don't think it's ever going to come to fruition, the proposed changes on OPT.
And just to clarify, if anyone else got confused there, I think I misheard it for a moment, but that was the Trump administration had proposed changes to OPT. And of course, there was, there were things with F1 that had been proposed, but the Biden administration recognizes the value of international students. And there have been recent articles in the past few weeks that have come out about expanding and really helping universities reach international students again and supporting them throughout the OPT process, because that is so vital to our economy. So I'm going to ask the next question from Arun. It says, how long is the perm process usually these days, and how are there any changes since Trump has been president? It's not just perm, it's all green cards, and I think we can talk about, Jeff, or Mike, if you want to talk about that, that'd be great.
Jeff, I can talk about the timeline for perms. I don't think that there's been so much change with the Trump administration in terms of perm and how long it's taking. That stayed pretty constant. It has gotten a little slower recently, maybe due to COVID, maybe other reasons. But in general, it's taking about, I would say, I'm just trying to do the math here, because there's various steps to the perm. So the prevailing wage, once you have a job description, you file what's called a prevailing wage with the Department of Labor, telling them the requirements, and then they tell you the salary that has to be paid for the requirements you're given. That takes about 4 months right now,
right,
for that to certify that. And then you've got about 2 months of the testing of the labor market, where you're putting ads in the newspaper and the various different forms of advertisement. So you got 2 months there. So now we're at 6. And then right now, once you file the perm application with the Department of Labor, it's taking about 5 months. So you're in the range of 10 to 11 months for the perm process, the first step of the green card. That has stayed pretty constant. It was down to maybe 8 or 9 months before, so it has creeped up, but not much change. And we all thought that there might be an uptick in random audits at the perm stage because of the unemployment level throughout the country because of COVID, where they would just simply ask randomly, let us see what you've done for your labor test. Did you receive any resumes? Show us the recruitment report that you've done. And we thought we might see an uptick in those, but so far that has not been the case. Those can really slow down the perm process. If that happens and you get a random audit from the Department of Labor, then the timeline is skewed. You're not really sure how long it's going to take. It can add many, many months to the process. But so far, so good. We haven't seen a lot of that. I don't know if you were only asking about the perm process and not the additional steps of the green card. But for perm, it's about 10 to 11 months.
the next question is, Jeff, you mentioned the national interest waivers, and you said that might be a more efficient process for folks as they try to avoid backlogs. So what are processing times for a national interest waiver right now?
Well, because the national interest waiver does not require a perm labor certification be filed. At our office, it takes about 5-6 weeks to put together a strong national interest waiver petition. We file it. Right now, there is no premium processing. I think that is coming. Congress told the federal government to start premium processing for national interest waivers, and they haven't. But right now, it's taking 10 months, an average of 10 months for a national interest waiver to be adjudicated. If the priority date is current, which it is for everybody except for Indian and Chinese citizens, you can concurrently file the I-485, which is the final green card application. And that's where you prove that you don't have any contagious diseases and that you do fingerprints to prove you're not a criminal and that you have to prove you're legally in the US. You can file that concurrently with the national interest waiver petition. That's also taking 10 months. So if you file them concurrently, you could have a green card in 10 months.
I'm going to try to combine some of these questions. First, very quickly, can you talk about where you find fair prevailing wage information for Massachusetts?
The website is called the FLC Data Center. It stands for Federal Labor Certification Data Center, FLC Data Center. And
Mike, can you just write that in the chat? That'd be great.
yeah, I'll put that.
And then I'm going to move to that's great. And then there's a question about H-1Bs again. It's about RFEs. I think that's really interesting. Like, what trends are you seeing in RFEs? And then if you have remaining time on your H-1B, are you able to transfer it to a different company? We talked about transferring already, but you know, we're talking about with the wage rules, how would the wage come into play? Would someone need to you know, reevaluate their wage during that period? And is there any grace period before the rule about the wage increase goes into effect? So if you want to take that H-1B one before we end.
Yeah, I'll take the H-1B one. So if you're applying for any H-1B, you know, regardless of how much time you've used or where you are in the life of your H-1B, you're going to be subject to the new wages. They went into effect immediately. Not only that, I had a case where we had filed. This was a green card case, but we filed under the old wages and it got certified after the new wages took effect, and they applied the new wages to that application. So the answer to your question is you'll be subject to the new wages as things stand now, unless something happens in the courts. And then there's no grace period. It just went. I mean, they gave us, I think it was a day or two, and then it just came. It was really absurd.
Yeah, and then just the last part on that H-1B was if you previously had an H-1B but didn't use all of your time, can you apply the remaining H-1B to another company?
I mean, the answer to that is yes. You can use any time as long as it's within 6 years of you being chosen in the lottery. You can use any remaining time that you have of H-1B, of 6 years of H-1B time with a new employer, but you will be subject to the new wage level.
Awesome. Any other questions can be sent to either Jeff's email, Mike's email, or my email. I think you should send them to my email. I'll definitely be the fastest to respond here out of the three of us. I'm going to aggregate them and send any additional things that were sent in the chat and make sure we didn't miss anything here. Thank you so much for joining. Oh, Mike, did you?
No, I was just going to say there was one about the typical RFE for H-1Bs. I was just going to say it's almost all the time it's based on specialty occupation. There are other things, but usually 9 out of 10 times it's specialty occupation.
Yeah, awesome. Ankita, I see your question. I promise we will get it answered, and if you can send that directly to us, we will send you a specific response. So thank you so much for taking the time tonight. We're very excited about a transition to the Biden administration. We think there's a lot of positive change that will come in the business immigration space. Please follow up with any additional questions and have a good rest of your night. Thank you so much.
Thank you.
I'll be sending the presentation out also to anyone who joined tonight.
Thank you very much.
Bye-bye.
Thank you.
Thank you.
Thank you.
Take care. Awesome. Lots of thank yous. Hopefully it was helpful then.
Okay, we should